Okay, well, hello and welcome to this month's webinar entitled Co-Founders and Business Partners Getting the Legal Foundations Right. I'm Alex. I'm the co-founder of Sprintlaw. Just before we get into the content for today, a quick introduction to who we are for those who are not already clients or members. We're an online law firm really designed to make legal services accessible and affordable for small businesses. Unlike your traditional lawyers, we don't charge by the hour. All of our legal work is done on a fixed fee basis. And we operate in all the different areas of law, from helping businesses get set up, helping with business partner agreements like we'll be talking about today, um, to drafting, your client contracts, your website terms, your privacy advice, your intellectual property protection, um, and employment law, and helping you if you need to raise funding as well. So we cover most of the areas of business law. We have an optional membership, but the majority of our clients sign up to it. It's a great subscription with a platform where you get unlimited quick calls with our lawyers. You can make some of your own free legal documents. It's got an e-signatures tool. There's some credits that you can spend on legal advice throughout the year, and the legal health monitor as well. There's a free tier for those that want to check it out. You can sign up on our website. And we're about to do actually a really major upgrade to the platform in a couple of months with a ton of new features as well. So it's a good time to sign up for those that are interested. We've been around for about 10 years. We are a fast growing business ourselves. So I've gone through many of the challenges that small businesses go through. And we now have a team of a bit over 70, and operate in 3 countries, including Australia, New Zealand, and the UK. And if you are gripped by the inexplicable urge to get some legal advice after this webinar, we're always happy to have a free chat. And we're doing discounts at the moment on some of these um, corporate type legal services. So just get in touch with our team to book in a call. We'll drop the link in the chat to book a consult, and we'd love to chat to you. So let's talk about the content for today. We're going to be um, analyzing co-founders and business partner relationships through a few different angles. First, we'll be talking about how your business should be set up and what is the correct sort of business structure for businesses that have business partners. There's a few different models. There's partnerships, there's company structures, there's more advanced company structures. So we'll be looking at a few of the different models and discussing what's common and what's often the correct structure for people going into business together. We'll then talk about the business partners agreement, which is called either a shareholders agreement if it's a company structure, or a partnership agreement if it's a business partnership. We'll talk about what they are, why they matter, and we're going to go through in the following section the key clauses that go in those agreements, what they mean, and why they might be significant for business partner relationships. We'll then look at the end at some other agreements when you're getting set up with a business partner that you might want to cover off as well, in terms of employment agreements, loans or finance agreements for people putting in money into the business, and then intellectual property deeds for IP arrangements. As I'm going through, we have a Q&A feature in Zoom. Do feel free to drop questions in along the way. I don't mind answering as I go. We might have a bit of time at the end, but yeah, it could be good to get the questions while we're on the slide, to add a little bit of color to whatever I'm talking about. So feel free to use that, and I'll keep an eye on the Q&A as we go through. So let's start by talking about business structures. When you're setting up a business with more than one person, um, there's a decision to be made when you register the business as to what structure you choose. Now, the most basic structures are on screen now. We have the sole trader structure and the partnership structure. These are free structures to set up, and you can sort of do it yourself through the ABR to register an ABN. A sole trader is a registration for an individual, where you can operate a business under your own name, an ABN, or a business name if you register one. It's fast, simple, and easy. However, when you set up as a sole trader, you are not setting up a separate legal entity for your business from yourself. And so it's quite a risky structure in that if something goes wrong in your business as a sole trader, you can be personally liable for issues that may occur in the business. So, for example, if you own a house, a car, and personal assets, and you're also running a cleaning business and something goes wrong with the client, and the client decides to sue your cleaning business, they actually would be able to potentially claim their losses against your assets, your house, your home, your car, whatever else it is that you own. So sole trader structures don't give a clear separation between the business and the individual. And also for the purposes of today, we're talking about co-founder relationships, business partnerships. Sole traders are for one person, hence the word sole. So this structure is usually not appropriate for people wanting to um, work with multiple people. You can have two sole traders working together through a contract. But in general, if you're going into business with someone, it's not usually the right structure. Then we have the partnership structure. The name might suggest that it is the right one if you're working with partners. It's a very simple structure. Again, the two people will go into business together and they'll form a partnership. They can register an ABN. Um, Now, that's also free to register online. You can get a tax file number also for this partnership and file tax returns sort of jointly for the income that comes in under the partnership. Again, though, like a sole trader structure, a partnership structure is not a legal entity separate from the business partners themselves. So if the two business partners own a house, a home, assets, and so on, in general, if something goes wrong in the partnership run business, the partners are liable. If they're 50-50 partners, they're 50-50 liable for issues that may arise in the business. Their house, their home, their assets, their car, all of that stuff can be on the line. So whilst these structures are simple, the sole trader and partnership structure, we as lawyers who are often in the business of helping you reduce your risks, we don't really like these structures as a way of running businesses with more than one person. Enter the company structure, which is the more robust way for people who are going into business in general to work together. You can of course, there are various versions of the company structure. There's the simplest single company structure, and then we'll briefly talk about the dual company structure and potential trust-based structures. But for people that are going into business with others, usually some form of company structure is an attractive way to set up the joint business. Now, why is that? Well, when you set up a company, unlike when you set up a sole trader or a partnership structure, you're actually setting up a separate legal entity, a separate legal being to the people that sort of own it or founded it. A company will have shareholders, which are sort of like owners, or maybe the body of the company, and it will have directors, which are sort of like the mind of the company, who can control the company. But the company itself is its own person. It has its own bank account. It can be sued by clients or employees or anyone else. And in general, the liability is limited to the company, which is why we have this concept of a limited company. That means a customer could sue the company, but they can't pierce through the company and go after the founders, the directors, or the shareholders of the company. In general, their house, their home, their assets are all protected. There are exceptions for things like fraud or exceptional circumstances or breaches of what we call directors' duties, but in general, the owners of the company have this benefit of limited liability. And so for a business partnership, when you're going to business with someone else, it can be a really great way to set up the structure. It also enables you to split the ownership with investors and other parties, through shareholdings and shares. So you can have 50-50 partners, 60-40 partners, partners that might own 40% each, and investors might own 20%. You can slice the pie much more easily with the company because you now have this separate entity with a pie that can be divided up. So it's a more robust structure for serious businesses. In the middle, we have the dual company structure. This is a more sophisticated structure, but many businesses that, particularly those that are IP heavy or have ambitions to really grow, will consider this structure. Now, you can see in this structure, we have, instead of one company, we have an operating company and a holding company. So the operating company is the company that will go out and employ staff and run the business and take on clients. It is not actually owned directly by the business partners or the founders of the company. It's owned by a holding company, which is then owned by the owners of the company. Inside the holding company, in this model, the business would store its valuable intellectual property or other property And if it's got tons of cash, it would hold it in some of it in the holding company. And this would sort of act like a safety deposit box for the company. So what would happen is, if a client tried to sue the operating company, they could sue the operating company for its assets, but the liability would be limited to the operating company, and they wouldn't be able to pierce through and get to the holding company, and they certainly wouldn't be able to pierce through and get to the underlying owners, of course, unless there was exceptional circumstances. So in this model, the owners have two layers of protection from the end customers, plus the holding company, if the business has valuable assets, also can protect some of its key assets too. So it can be a nice structure for particularly as your business starts to hold more and more value. And it also creates this two-level structure. And so if you decide to expand the business into other countries or other markets or other business lines, you can create multiple what we call subsidiary entities and start to silo the risk of your business into multiple buckets. So for example, Sprintlaw has Sprintlaw Group, which is our holding company. We have Sprintlaw, our Australian operating company, Sprintlaw UK, our UK operating company, and so on. And our if something goes wrong in Sprintlaw UK, the liability is limited over to that UK entity, and it doesn't affect our holding company or Australian operating company in most instances. So you can see how that model starts to make sense if your business wants to expand. Um, but for many people, the single company structure may be the simplest option. Now, on the right, we have the trust structure, and this is an even more sophisticated structure, but is quite common. Now, I've got a little asterisks here because people may be aware the 26-27 federal budget has proposed some changes to the way that trusts work. So this was a very common structure before. It may or may not be a common structure if these changes go through in 2028. But to explain how this structure works, in principle, you have um, not only do you have the business partners, holding their shares in the holding company or the operating company at this top level, we've also introduced another company in the middle called the founder trust company. And what this means is, in these models, you can see the founders are protected from risks with employees and clients. But right at this top level, if there's a dispute between business partners, they are sort of co-owners of a business, and there's no company sitting in between the two of them. They've are working together sort of at this level. And so this means that whilst business partner one and business partner two would be protected from employee claims and protected from client claims or business claims, they could potentially sue each other if there's a falling out. So introducing a trust company can add another shield. And you can see here, founder one is now very protected in this model. They've got a shield from the employees, a shield from the contractors. They've got their holding company, and they're hiding behind their trust as well. So founder two, if there was a claim, their trusts could sue each other in relation to their business, but it will be more difficult for them to come after each other's personal assets. So that's one reason people do trusts. It gives this extra layer of what we call asset protection or liability protection for the owners. Um, Another reason people used to use trust companies rather than just companies in general was under Australian tax law, there could be advantages if the company was issuing dividends or if it was sold to having the funds flow not to the owners of the company directly, but into a trust they control to enable the founders to distribute the gains in various ways that might provide tax favorable outcomes. Now those have been muted a little bit by these potential changes. So the tax benefit is less clear, but from a legal perspective, this is still advantageous anyway to at least have either a company or a trust company in between the founder and the business, because ultimately, from a legal perspective, rather than a tax perspective, what we're trying to think about is how can we reduce the most risk when we're going into business. And this kind of model is safer than this model. Now, you don't need to have the dual company structure with the trust. You could have a single company, but the founders could hold their shares through a company or through a trust. So you can mix and match a little bit, but this is kind of a lay of the land in terms of how people think about structures. For many people who are just trying to do a simple small business partnership and going to business with someone else, usually they just go for a single company structure. Sometimes they'll hold their shares through a trust, or if their accountant advises it, or a company. But this is probably the most common approach. But for startup companies that want to raise capital and expand, probably the dual or the right model is the more common approach. We do see some small businesses set up as a partnership. Um, Usually it's because they didn't want to spend the money of setting up a company, but yeah, we as lawyers generally don't like this model unless there's a particular reason that you have to be a partnership. I mean, in my industry, in the legal industry, for many years, the law would not let you have a company to run your business because they didn't want the lawyers to hide behind company structures. And so most law firms had to be partnerships, which is why you have these law firm partnerships, because the owners and partners had to be liable to the end clients until about the year 2000, where they allowed the introduction of company structures for law firms, but with some conditions attached. So there is still some personal liability for the owners. So in case you're wondering why you do see partnerships out there in the world, particularly when lawyers are telling you not to use them, it's often because there's a regulation, not because it's actually the lowest risk structure. So hopefully that makes some sense. So I won't go through this in detail, but this gives you a bit of a flavor for the differences between the different structures from sole trader, partnership structure. You can see there's all kinds of downsides in terms of liability. It can be difficult to raise funding. What happens if one partner leaves and one partner joins? It gets complicated. Versus the company structure is a nice middle ground. And then the dual company has more advantages, but costs a little bit more. In terms of the costs, to set up a company structure is probably about $1,000. You can do it yourself cheaper online. There are self-service company registration tools. Sprintlaw actually launched our own self-service company registration tool a couple of weeks ago, which is, I think we charge $50 or something on top of the $600 ASIC fee to register a company. So it's not prohibitively expensive to get the company set up. Then there's a renewal fee of a couple of $100 a year. So people think it's tens of thousands of dollars to set up a company. It's not that expensive if you were budgeting $1,000 a year for company admin. That's sort of what we're talking about. There are contracts and things to do. You'd have to do them anyway under a partnership, which will cost some money. But for the actual structure, for the risk protection, simplicity, and advantages it provides, it can be a good investment. So hopefully that makes some sense. And I've put the note here that the trust company structure has a bunch of advantages, although the tax advantage is a bit unclear at the moment, given we have some pending changes to the trust laws. So once you've set up your business structure, or for those of you that already have businesses set up with a business partner, the next question becomes, do you have any kind of agreement or contract governing the relationship? Now, when people set up a company, usually if you set it up with an accountant or using one of the online services, you get a whole pack of documents, including like a constitution and a share register and all these other sorts of things. And people think that, okay, there's something there governing how all this stuff works. I don't need to think about it. But those documents are very much templates. And what you really want to do with your business partner is have a contract or get something in writing from the beginning describing how everything's going to work, how a decision's going to be made, how a dispute's going to be resolved, what happens if one person wants to leave, one person wants to stay, what happens if one person wants to sell, and one person doesn't. What things do we need to come together to agree on? What things can we just sort of go off without having to be so formal about it? How often are we going to issue dividends? What if someone is injured or passes away? What happens to their ownership stake? There's a whole bunch of considerations that suddenly arise as soon as you go into business with someone else. And these things are not just automatically covered, by the law, because the arrangements that you might want with your business partner are very specific to your situation, the dynamics of your relationship, and what's going on in your life and where the business might go. So, lawyers have written these kind of agreements for many years, and we know what the common issues are. So we can ask you the questions. What do you want to happen in this case? What would you like to happen in this case? This is the kind of different options people choose, but the right option for you will often depend on your circumstances. And so this document, the shareholders agreement, or if you're a partnership, it's called a partnership agreement. But if you take the company structure, it's called the shareholders agreement between the shareholders of the company. This agreement is one of the most important documents for your business. And I will say it's not a compulsory document, but it is at the top of the recommended list of documents that people who are going into business partnerships do. And one of the number one reasons for a business failure that we see and for often litigation or issues at the end of a business is due to either like a self-written shareholders or partners agreement or having no shareholders agreement. And the reason for that is sort of predictable. Oftentimes, disputes between business partners happen because one party's gone off and done something the other party thought that they shouldn't have. And it wasn't clear whether they should have or shouldn't have because they never had a clear conversation about it because they never had a shareholders agreement. So one of the big advantages of these documents is not that you're necessarily going to be suing each other and looking at the fine print. It's actually setting the ground rules for the relationship and preserving the relationship so that the business can run smoothly with both parties understanding what they can and can't do, if that makes sense. So they are really quite important documents. And um, in the sequence of things, when we set up Sprintlaw as an example, the first thing we did was set up our company. The next thing we did was our shareholders agreement, and then we did our trademark. Those are kind of the top three things on our to-do list at the beginning of a company. So for those of you who have set up businesses and you haven't knocked off those three, I would encourage you to put this in your top three list. And for those that have used a template or don't really know what their agreement says, again, these are not like a very basic website terms and conditions or an NDA. They're lower risk documents unless you run like a sophisticated web business or you have very confidential information. For many people, documents like that, there are templates online. You can generate one with ChatGPT or something, and it might not be a huge risk. But for a shareholders agreement, this is a document that can have, if you believe in the business, can have significant financial ramifications if not done correctly. It can be drafted in a million different ways, and it can have outcomes that might make sense for a lot of people, but don't make sense for your circumstances. So you really want to get this one done correctly. And we have on screen some of the reasons they're important. As I've said, gives you clarity as to what happens in different situations, avoids disputes. It's going to protect parties' interests, particularly if you have business partners that are not equal. One owns more than the other. You have 3 business partners, 4 business partners. Um, so there are different um, uh, sort of mechanisms of control in those cases that you want to manage. Otherwise, for example, minority shareholders might have no say in the business. You have control over ownership. How do we stop third parties getting in and getting influence on the company? And you have business continuity. These situations where there's a disability or there's the departure of a shareholder or there's a death, what happens in those cases? So these are the kinds of reasons that you're wanting this agreement because it's dealing with a lot of these things. Jermaine's asked the question, what is the legal relationship between the SHA, the shareholders agreement, and the constitution in a company? That's a good question. So I mentioned earlier when you set up your company, uh, usually if you set it up through a lawyer or an accountant or even using one of the online tools that exist, it will auto-generate for you a document pack, including this thing called a company constitution. So a constitution is a document that sets out how the company's practically is run in terms of how decisions are made. Do we run a meeting? How many people need to attend a meeting for a decision to be made? Who needs to vote at a meeting? Et cetera, et cetera. It has some sort of practical rules about the running of the company. It doesn't go into detail about all of these sorts of things. What happens if there's a dispute? What happens if what decisions specifically can be made that require the approval of everyone or require the approval of a few people. It's not a very customized document. It's just a sort of templatized document that that has the procedural items involved in running a company. Now, many years ago, lawyers used to take the constitution of a company, which would start off as a very generic document, and they would edit the constitution and they would do all of the things that I'm talking about in a shareholders agreement. They just put it in the constitution. And that is one way to manage the same risks, is to have a sophisticated constitution. The problem with the constitution is a document that is regulated by the corporation's law. And in some cases, majority vote can enable the changing of a constitution. And so if you've got a situation where you have minority shareholders who want their approval before decisions are made, there are workarounds where under this constitution document, you could have a majority sort of use their power to get the document changed and undermine some of the ideas or principles that you might want in the running of the company. And that's sort of just one example. So the constitution document um, is usually not used for the more tailored type flexible relationships that we want to have between business partners. It can be used, and some people still work that way, but most modern businesses are running with a very simple constitution that just talks about how meetings are run and those sorts of things, and a more tailored shareholders agreement, which will evolve over time as the business partnership evolves. So hopefully that makes some sense. It's a bit of a technical point, but that's why they're sort of separate documents. So um, Anjuman said, does one overrule the other? Look, in the shareholders agreement, it usually has a clause that says, to the extent of any inconsistency, the shareholders agreement will prevail. That said, there are laws around things that you can't do in a shareholders agreement, and so it might overrule that general position. So usually, yes, the shareholders agreement is going to overrule the constitution to the extent that it can, but there are some circumstances where it can't. And again, um, without getting too technical, um, you can think of this as really the primary document, if that makes sense. So what goes in this shareholders agreement document? Well, a shareholders agreement document, you can picture as a very long legal contract. Sometimes it can be 20, 30, 40 pages, which covers a whole bunch of eventualities that might happen in the business partnership. Now, it's a long document because there are a lot of things that can happen and that need to be thought through as soon as you go into business with someone else. And so we need to think through all the different mechanics, and a lot of that is what's in the agreement. Now, much of the document is going to end up being fairly generic or templatized because, again, many of these issues have been dealt with before, but there are important parts of it, the parameters around how the document's drafted, that vary greatly depending on, as I said, your relationship with your business partner, the number of shareholders, and how you want the business to be run. But so these are the kind of big ticket issues that we're considering in a shareholders agreement: decision-making processes, how are decisions made, vesting schedules. We'll talk about this, but what happens if we found the company 50-50 and then one person leaves after a week? Do they still get to keep their 50%, or do they have to stay for a period of time to vest or have their percentage really lock in? Drag along and tag along clauses. These are situations usually more for non 50-50 partnerships when you've got majority shareholders and minority shareholders. Can the majority sell the share without leaving the minority behind? Can the minority sort of tag along in those cases? Or can the majority force the minority to sell if they have a good acquirer appear? So clauses covering those kinds of eventualities. Termination: how does this agreement end? How does the business end if we want it to end? Right of refusal: what happens if we want to bring in more shareholders, or can we just bring them in, or do we have to offer them to offer the shares to existing shareholders first? How and when are dividends issued? How are disputes resolved, and restrictions around shareholders potentially setting up competing businesses. So we'll go through these in a little bit of detail. We'll start with the decision-making processes. So these are, as I said earlier, clauses about how decisions are made in the company. And in general, what you'll have in a shareholders agreement is a list, usually at the back of the document, of key decisions. And it will say this list of key decisions must be approved by X percentage of directors. It might say 100% of directors or 75% of directors. And in some cases, it might say these decisions need to be approved by X percent of shareholders. It might say 75%, it might say 50%. So people think often when you're working with multiple owners in a company that it's just going to be majority rules. It can be majority rules. It can be a simple majority, but it might be the case that you have certain decisions can be made quickly by a majority, but big decisions need unanimous approval or need majority approval. and they might need approval of directors of the company or shareholders or both. Now, I mentioned earlier in a business partnership arrangement, if you're using a company structure, you have the shareholders who are sort of like the owners of the company, and then the directors who sort of control the company and can sort of sign contracts and control the bank account. And the shareholders can sort of vote on things and vote in the directors, and then the directors kind of make those decisions. Usually, if it's a simple sort of two founder structure, the owners might be both 50-50 shareholders and both might be directors. So it might be that it's the same people, the directors and shareholders. But in many businesses, particularly as businesses get larger, you might have many shareholders, investors, minority shareholders, people that own a small stake of the business, and then you might only have a couple of directors who are actually signing off on the big decisions of the company and controlling the bank account. So the roles can drift over time. And when we're thinking about decision-making processes, in the shareholders agreement document, we're talking about what decisions can the directors make without needing to consult all of the owners, and what decision do they need to consult all of the owners and get a vote from shareholders. We're also talking about what can one director do, or one person in the business do, without seeking the other's approval, and how does that process work? So it might be the case that the schedule at the back says decisions involving hiring people with salaries of above $150,000 a year needs to get approved by the directors, but lower salaries can just be done as part of business as usual. A change to the direction of the business might need approval from the majority of shareholders because the whole business is changing. A sale of the business might need approval from a majority of shareholders. Taking out a loan of more than $50,000 might require approval of just a majority of directors, but taking out a loan of over $500,000 might require approval of all the shareholders. So you can imagine a list at the back of the document describing the different situations and describing what needs whose approval and what percentage is required. So those variables are a decision for you. If you're setting up the business with a business partner, you will decide what you're comfortable and not comfortable with. And the lawyers will draft that into the document. But that's sort of how we're governing decision-making processes. On the right of the screen, we have the right of refusal. So in a shareholders in a company scenario, you'll have a situation where the business partners will own shares in the company. Now, maybe one of the business partners wants to bring in a new shareholder or a new investor, or maybe an existing shareholder wants to sell their shares to a new potential shareholder. Now, if A goes into business with B and wants to work with B, but then B says, hey, I'm going to sell half of my stake to C, and now B and C are both in the company, A might not be so happy about that because they don't know who C is. So this clause is designed to cover that scenario. Now, we're not going to be so draconian often to lock up B from ever being able to transfer their shares without A's approval, although some shareholders agreements might do that. But often we have this thing called the right of first refusal. B will say to A, hey, I want to bring in C. They've offered to pay this much for my stake in the company. You have the right of refusal. If you can match C's offer, you can buy out my stake. Otherwise, I'm going to bring C in. So that's kind of what a right of refusal often does. Similarly, for those that have seen that movie, The Social Network, you can imagine scenarios where we have two shareholders of a company. There have been cases, including purportedly, and this is simplification, sort of what happened at Facebook, where one of the business partners decides to issue themselves way more new shares so as to dilute the other business partner and take control of the business. And so there are protections around that as well. If the company is going to issue new shares at any value, it must offer the same deal to all of the existing shareholders. So you can't just give one person a whole ton of
of shares in a business at 1 cent and dilute another business partner or another investor, they have the right of first refusal to also get the shares issued on those same terms. So these protections you can see are important protections to make sure if you're going into business with someone that A, they can't manipulate things to increase their own stake and dilute you from having a say in the business, but also B, other parties can't be brought into the business without at least giving you the right to have that stake that's going to be transferred. And there's different laws around how the right of refusal works. Sorry, different drafting styles around how the right of refusal works. It might be that there's a 7-day period where someone has to respond. One business partner or shareholder has to respond, saying that they want the shares or not before they get transferred. There's different triggers. There's exceptions sometimes for moving stuff from your own name to like a related company's name where you don't need to go through this whole process. So there's a bit of technical legal aspects to this, but the overall concept is protecting the introduction of new shares or new shareholders without other parties having a say. Now we'll talk about vesting schedules. I touched on this earlier. Vesting, this term refers to basically a timeline for earning the right to own shares. Now, if you're going into business with someone and you're splitting the pie 50-50 or with three people, a third each, everyone will have chunky stakes in this business. There is usually an impression that everyone is going to stick around and stay involved in the business long term. But if one person decides to pull out, you may not want to end up in this situation where they still own just as much as everyone else who's still working in the business. And so it's quite common for business partners to introduce what we call vesting schedules, which is a timeline for earning shares. It might say, look, we're all going to own, let's say there's 4 business partners, we're all going to own 25% of this business. However, for us to really lock in that 25%, we've all got to stay working in the business for 4 years. If anyone leaves in year 1, they're going to just lose their whole 25% stake. If they leave in year 2, we'll let them keep 10%, but they're going to lose the other 15. If they leave in year 3, they might keep 15 to 17%. And then if they stay for the 4 years and then they leave, fine, they can keep their 25%. So that's an example of a vesting schedule. The timing, the percentages, all of them can be customized depending on your circumstances. But you can see how this vesting schedule is a critical protection, really, for business partners that might not stay involved in the business long term. Now, even though this is a really important document, a lot of shareholders agreements that are drafted don't contain vesting schedules because whatever reason, a lot of people don't like doing them. I guess it puts your own shares at risk, even though it might protect you from other people's having shares which they may not have fully earned. So I think that's a problem, and I think people should really consider putting investing schedules. But I will say it's not as common, I think, as it should be in shareholders agreements. And what we do see typically happen is even if original founders or business partners of a company don't have the vesting schedule, later on, if they take a significant investment from someone who's going to put $1 million or something into the business or $500,000 or some substantial amount of money, that investor says, hey, I'm happy to put in this money, but we can't have one of these business partners leave. So the vesting can often get introduced at the time of investment, not at the beginning of the company, and the shareholders agreement often gets amended. So that's a common time we see vesting being introduced into a shareholders agreement. But really, it is a very good idea to consider it from day one. We're going into this together, but if one of us pulls out, you can't keep that stake forever, if that makes sense. Dividends are another really important point. Now, for businesses that are going to be turning a profit and wanting to distribute it, the shareholders agreement can describe how that's going to work. Are dividends going to be issued quarterly? Are they going to be issued monthly? Are they going to be issued once a year? How much of the profits are going to go back into the business and how much are going to be given to us as business partners? Who needs to approve it? If we need to make an exception to the policy because we had a bad year, like how's that going to work and what are the approvals going to be? So This can be drafted with specificity or flexibility, depending on what you want to do for the business. But it's a very important point because, again, otherwise it can be unclear when money's coming out of the business and how that whole process works. And it can lead to a dispute between the business partners. Many people decide that they're not going to lock in a dividend policy and they'll say, look, we're going to the clause can say dividends will be issued when in the amounts and at the times that the directors deem appropriate, so they don't have to be locked in the shareholders agreement. But even that is a valuable thing to put in the shareholders agreement because at least then the business partners know that they've agreed to have it run this way. Now, where we get issues is when it hasn't been discussed or hasn't been clear, and you end up with a dispute emerging between business partners really due to a miscommunication, not due to anything else with the business, and that can really spiral out of control, particularly as it involves money. So it's an important conversation to have to think about how you want dividends to work. And as I said, it doesn't have to be locked in, but many shareholders agreements will at least have a annual review clause for the amounts of dividends and reserve a certain amount of money to go back into the business unless otherwise agreed, if that makes sense. Got a question from Selena. How does the vesting schedule tie in with ESOP and when employees exercise the option to become shareholders? What if you don't want employees seeing the upstream arrangements between founders? Yeah, so that's an interesting question. The I'm just thinking about how I can answer that without opening a can of worms around what ESOP is. But for those who don't know what an ESOP is an employee share option plan. So we're talking today a lot about business partners having stakes in the business, but you can also give employees usually small stakes in the business as well. Usually you don't give them shares in the company, so they're not a co-owner. You give them options in the company, the option to buy shares. And so they effectively have a stake in the business, but they're not actually an owner. And just like I was talking about vesting schedules for the owners of the business, it's very common if you're going to give shares or option to an employee of the business that you would also have a vesting schedule. If you stay employed at the business for 4 years, you can keep these options. If you leave after one, you won't get any, and so on and so forth. So the concept is the same in terms of vesting. In this context, we're talking about it for business partners, but it can also be used if you decide to give employees a stake in the business. In terms of what happens once the employee has got all their options, depending on the terms of the options, employees can convert the options into shares. Usually they have to pay a price to do so, so many will not do that, but they can convert their options into shares and become part owners of the business. And in some cases, they will then become a shareholder. They'll join the shareholders agreement. They'd get a copy of the shareholders agreement. And to Selena's point, they may start to see the upstream arrangements between the founders and the investors of the business. So that is actually the default position that they can. If you want to avoid that, there are things you can do where, when employee option holders get their stake in the business, they have a separate class of shares, Class B shares, which give them a less of a stake or an ownership right in the business and doesn't expose them to see the sort of Class A arrangements between the owners of the company. So there are workarounds if you want to allow employees to become owners and not get full exposure to how everything works. It's just a matter of structuring it that way. But yes, it's a good point to raise. And we're talking a lot about the business partners here, but again, you can have employees that end up as pseudo business partners under these sort of option plans. So now looking at some other important clauses in the shareholders agreement, we have the drag along and tag along clauses. So I touched on this earlier as well. In a situation where you end up with minority and majority shareholders in a company, we now have these concepts of drag along and tag along. What happens if the majority, someone who owns 75% of the company, wants to sell their stake to a potential acquirer, and they are keen to sell, but the minority shareholder with 25% does not want to sell their shares, and the acquirer says, well, I don't want to buy 75% of this business. I want to buy the whole business. That situation where a minority could block the deal and then theoretically say, all right, well, 75% owner, if you want me to agree to this, you're going to have to give me a really good deal. I want more than my stake entitles me to, or otherwise I'm going to veto this thing. That can really cause problems and give minorities too much power. And so we have this concept of a drag along clause. If more than X% of the shareholders of a company want to sell, they can force a minority to sell with them on the same terms. So a big decision, of course, is what is the percentage and what is the right to drag along? Is it just a majority can force the minority to sell, or do we need really 90% of people to agree before we drag people along? But that's a concept you can imagine can emerge, particularly in asymmetric shareholder arrangements. Similarly, we have the tag along clause, which is the inverse. What if majority shareholders negotiate a great deal for themselves to sell 75% of the company and they want to leave the minority behind? The acquirer can save a bit of money. They just require a controlling stake in the business, but they don't have to buy out these minority shareholders. Well, that might be too advantageous to the majority shareholders. So similarly, you often have a threshold which says, look, if 75% of the company's been sold, it can't be done without 100% being sold. The minorities have the right to tag along on the same terms that the majority are getting. So that protects the smaller shareholders from being sort of left behind. So these clauses, again, are fairly standard in terms of how they work. The decision to make when you set up your business partnership is what are those percentages going to be, and how's that going to work, if that makes sense. So something to think about. Finally, we have our dispute resolution clause. What happens if there's a fallout between business partners? Now, sadly, this happens all too often. And it's one of the most common things we see at Sprintlaw is business partnerships breaking down for various reasons. Uh, the um, the process for resolving disputes, if there's no contract, is very uncertain. Basically, the business partners can start suing each other and threatening each other with all kinds of things, and you can end up in a costly litigation, particularly if there's a lot of value at play. Um, to avoid that, a good dispute resolution clause can really reduce the risk of ending up in court over a business partnership dispute and actually help to resolve disputes. A typical clause might look like the following. It might say, if there is a dispute between the shareholders that can't be resolved informally, the following process will apply. First, the parties will attempt to resolve in good faith and must at least meet either in person or virtually to discuss the issue and attempt to come to a practical conclusion. If no practical conclusion can be reached within X days, the parties may commence formal mediation. And mediation is a a method of dispute resolution. There are, professional mediators that will handle a dispute. It's not like a court. The mediator doesn't make a decision that is binding on the parties. Rather, it will attempt to speak to both parties and negotiate a compromise that both parties are happy with to get things moving along. And it's much, much cheaper than engaging in litigation. And oftentimes you don't need representation in a mediation. So there might be a mediation process. And if that breaks down, you might then go to an arbitration process, which is a sort of non-court but court-like decision-making process where an arbitrator will hear all of the facts outside the formality of a courtroom and come to a decision on the point of dispute, which would then be binding on the parties. So having a dispute resolution cascade like what I just described, and it doesn't have to be that drawn out, and it doesn't have to go through all those three stages. You can just do mediation, or you can just have the meeting, or you can just do arbitration and skip the mediation. But it helps really weed out the risk of a small dispute blowing up into an extremely stressful situation where both parties are in court and suing each other, racking up legal fees. And surprisingly, even the first step of having the parties meet and attempt to resolve it, which they're required to do under the shareholders agreement, we do see resolve issues, even if you might be skeptical and think, well, if they were going to resolve it themselves, they would have. Well, it actually does work. So now the way it works under the shareholders agreement is you actually can't sue the other party until you have done the things in the dispute resolution clause. So if one shareholder starts like making legal threats against the other, um, those legal threats are muted by the need for the dispute resolution process to happen. And so it stops a little issue immediately escalating into lawyering up, and again can massively reduce the risk of disputes ruining business partners' lives, for want of a better phrase. So I do think it's an important clause. Sometimes you see issues emerge with 50-50 shareholders where there's a deadlock, a majority approval is needed for something, and the two parties can't agree. And it can be difficult to figure out how to resolve those disputes. Sometimes you see in dispute resolution clauses quite aggressive things which say, hey, if there's a dispute and it can't be resolved, one party can just buy out the other party instead of suing each other. And both people will, write their number on a piece of paper, and whoever's number is higher gets to buy the other one out. And so you sometimes see that being a method of dispute resolution. Um, we don't draft that common, and I'm not the biggest fan of doing things that way, but that is, again, another way that disputes are often resolved in shareholders agreements. But there's many ways to handle disputes which don't involve going to court and suing each other, and you really want to avoid that, I think, in general in your life if you can. So these clauses can be very important. And without a shareholders agreement, it's not clear what would happen if there's a falling out between business partners. And just onto the final section with the shareholders agreements, we have the termination clauses. What happens if we want to replace this agreement? How will this agreement end? What happens if the business is sold or winds up? How do we end the company? What needs to happen? Making that clear and having a formal process. If a business doesn't go as planned and sort of fades away, having clarity around what the actual finish point is and how that works is very important. Otherwise, you could have a messy end. And similarly, when a business is sold, understanding how that process works, and what approvals are needed, and how this agreement would end there could also be very critical. So having clear clauses around that is quite important. And then we have our non-compete clause. One big worry that people have in going into business with someone else is that they're going to work together, share all kinds of ideas, and then one of the business partners is going to take all the clients, take all the ideas, and go to a competitor or start their own business. So very important to have a clause in there stopping that, and it's a way of preventing, again, one business partner being cut out of the business by the other one taking everything and setting up a new business. So again, there's different ways to define what non-compete is, how broad it is. Is it anything in the industry or just a direct copy of the business? You may not want to unduly restrict someone who leaves from doing something else, but you also may not want to be too narrow so that they couldn't take all the ideas and the clients. So the drafting of that is quite important. So those are the clauses of the key shareholders agreement. And again, that's the number one most important document to put in place between two business partners. There are other agreements that you might put in place on top of the shareholders agreement, to the extent that the business owners are working in the business, which often they are. They are not only shareholders and potentially directors, they may also be employees. And so an employment agreement should ideally exist between the owners of the company who work in the business and the company entity, setting out what their pay is, how much are the founders or owners going to get paid, when do they get paid, is one getting paid more than the other because they're doing a different role, what's their compensation. You don't only have to be paid through dividends when you're running a business. Again, if you take the example of Sprintlaw, we have when we founded Sprintlaw, we were a 50-50 shareholding arrangement. And we had a shareholders agreement in our company, but we were also employees, and we had employment agreements, as people running the company, and paid ourselves a salary with superannuation and everything else. It was not much to begin with, but it grew over time as the business did better. So, really that's how you want to be setting things up in many cases. For business partners working in the business, you're not only shareholders, not only directors, but also employees. And that's what the employment agreements are for. You may also want to have an IP agreement that can be covered in the shareholders agreement, that can be covered in the employment agreement, but usually to be safe, we recommend that founders of a business sign a simple 2-page document that says, hey, anything I create for this business So in my case, I sign a document. Anything I create for Sprintlaw related to Sprintlaw to do with Sprintlaw is, hereby in the past and in the future going to be owned by the Sprintlaw company. And that's important because if you're setting up this joint entity and all of this new ideas and intellectual property and copyright is being created, you want to make sure that that's not owned by the author who created it, but it's clearly owned by the company. So a document like that's a good idea to sign, just to be crystal clear what's owned by the company. Um, and finally, oftentimes, founders of a business will put money in to the business as startup capital. If one founder is putting in more than the other, um, it might be agreed that that money might be paid back before we start talking about dividends and shareholdings and wages and other sorts of things. So um, we often are writing loan agreements between founders and the company saying, hey, this founder has loaned $60,000 to the company. It's agreed that it will be paid back from the revenue of the company, 5% of the revenue of the company until the amount's repaid or something like that. So documenting any injections like that properly is also a good idea. So there's not disputes later of, oh, I put in more money than you, I should get more than you. Well, let's properly document what that money was. Was it a loan or what was it? And if it was a loan, how and when is it getting paid back? Um, so yeah, ancillary documents to that sort of key doc. So that was all of the content I wanted to cover for today, and hopefully people have found that useful. We've got a couple of minutes, so I'm happy to take any questions if people want to drop it in the Q&A. But yes, otherwise, as I said earlier, if you do have questions about these documents, you want to get a shareholders agreement done, do feel free to reach out to our team, and we'd be very happy to help. So I'll just wait for a minute and see if we get any questions coming through. Christina's asked, whose responsibility is it to I assume you mean to do the shareholders agreement? Um, well, so the parties to a shareholders agreement are usually they are the shareholders of the company and the company itself. Um, now, there's different ways to get it drafted, but usually, at least the way we do it at Sprintlaw is we would act for the company, not for any individual shareholder. So, we would draft essentially the first version of the shareholders agreement, and we'll say, and we might speak to all of the directors of the company at the time and ask them the questions, and they might discuss between themselves how they want it to work. But we'll normally act for the company, not any individual shareholder, and then we will prepare the shareholders agreement, and we'll say, okay, this shareholders agreement was prepared from the perspective of the company, not any individual shareholder. And you, as an individual shareholder, may want to get your own legal advice to make sure it suits your interests. And people may get it reviewed. Many times for startup companies, they don't get it reviewed. They're comfortable, with the company version. But it ultimately is a document you're signing as an individual, or if you're holding your shares through a trust or a company, I guess through that trust or company. But it's specific to your interests, how you might want this thing drafted. And so, if everyone had unlimited money, each party would have their own lawyers representing their interests. In practice, as I said, it may not work that way for smaller businesses, but for bigger businesses, certainly everyone has their own lawyers. Sometimes you would have, if there's two business partners, one person gets their own lawyers to do the first version, then it goes to the other side's lawyers, and they go back and forth, and that can work too. It can get a bit combative if the lawyers aren't cooperative, but again, technically, and not even really technically, actually, the interests in this document are maybe different between the two business owners. In the other documents you might do, like your terms and conditions and your employment contract and your privacy policy, it's just for the company. So, everyone's going to be aligned usually on how those work, but it is something where you might consider having a second pair of eyes. But as I said, oftentimes Sprintlaw will act for the company. Um, uh, Gerard said, perhaps already covered, do you have to register your shares agreement with ASIC? No, you don't. It's a private document, and it can be confidential. It usually is confidential. And so the contents of it it usually has a confidentiality clause. So the contents of it are usually only known by the shareholders themselves, unless, it's decided to distribute it, to other parties. So yeah, that's sort of how it works. And yeah, Christina, looks like you have a fault point. One of the shareholders registered the company but didn't do the rest. Um, yeah, I mean, that's it's not any one person's responsibility to actually do the shareholders agreement when um, when the company set up. As I said, this document is not a compulsory document, but it is a really important document. So if you have a company that's been registered, but you haven't done the documentation, you haven't got even the constitution, which is one of the more template docs. But certainly, if you don't have the shareholders agreement, it can be any of the shareholders that raises it and says, "Hey, we should do this agreement." And assuming everyone agrees, because everyone needs to sign, you could then organize for the someone to get the first version on behalf of the company, and then everyone has the chance to review it and potentially have their own lawyers look at it. Okay, well, oh, I've got another question. As a separate document to SSA, do you need to register your constitution with ASIC? No, interesting. You don't even need to register your constitution with ASIC. In the UK, you do need to register your constitution with Companies House. So, and it's public and everyone can see it, which is another reason why shareholders agreements in the UK are much more common than constitutions. But in Australia, constitutions don't need to be registered for private companies. Yeah, it is also confidential. But as I said, it's usually these days a very template and generic document in most cases. Yeah. If a company registered a trademark but registered the owner's name as the company name, what are the disadvantages in this case? So if a company registered a trademark but registered the owner's name as the company name, what are the disadvantages in this case? Um, don't fully understand the situation, and also if it is a specific situation, it probably requires specific advice rather than me being able to answer that publicly. I will say the usual way of doing things is a company name will be uh, sort of like the business's name. It doesn't have to be like you can register something called a business name for a company, which is different to the name of the company. And then a trademark is a third thing, which is sort of a registered protection. So, for example, in the case of Sprintlaw, our company in Australia is called Sprintlaw Pty Ltd. We have a trademark for the word Sprintlaw and our like logo, Sprintlaw, and we have a business name called Sprintlaw, and they're three different things. So you got the company name, the sort of trading name or business name, and then the brand name. And usually if it's a business with a brand, it would all be like we've done Sprintlaw Pty Ltd, Sprintlaw, the brand name, Sprintlaw, the trading name. If you have like a trademark over here and then a very specific company name that doesn't match it, that can be okay, but it might just be confusing. So it's possible to change the company name with ASIC. There's a fee to do so, but if you wanted to do that for clarity, you could. And you certainly need to have a registered business name as well. If your company name is not the same as the name that you use for your business, sort of with clients and so on, there's this third registration, which I haven't mentioned, called a business name registration that you need to have. So I would suggest having a look into that. But again, if you need some specific advice, might be worth reaching out to the team. Okay, well, I hope people found this useful, and yeah, thanks for all the questions. And we do this every month, so do feel free to come along again next month. Otherwise, I'll see you all later. Thanks.